please. So good morning, ladies and gentlemen. It's a great pleasure and honor to have here Dr. Balázs Rigó. We are continuing our transatlantic lectures, and it's another opportunity of being together and creating law culture together. So you have the floor, Dr. Balázs Rigó, and thank you very much for being here and for accepting our invitation.
Thank you, Professor Vasko. And at first, I would like to express my gratitude to the organizers to let me participate among the distinguished professors with a not sometimes popular, sometimes interesting, but not so beneficial in economic sense topic with legal history. But at the end of the lecture, I will show you some points when legal history can be more than beneficial, so you can measure your the money you can get from it. So at first, I would like to share a screen, and I hope that will work. My name is Balázs Rigó, and I work at the Department of Roman Law and Comparative Legal History, the Faculty of Law, Eötvös Loránd University. And the question that this lecture will focus on is that, is legal history a separate discipline in the intersection of history and jurisprudence, or is it a subdiscipline of either? Since besides teaching comparative legal history from the year 2012 and having both a legal doctorate and a bachelor degree in history, moreover, just having absorbed the master level last week, I'm facing the contradictions and controversies of the approach of the two professions, so that of legal scholars and historians. In other words, I am troubling with the two identity of being a legal historian. Therefore, I do research and spend much time on thinking on the evolution of the two professions and approaches. Thus, my main objective is to understand and reveal why and how the legal and the historian's professions separated when they were more or less the same at the first decades of the 20th century, and lots of historians of the Faculty of Humanities and legal historians of the law faculty had the same working language, method, and approach when they dealt with constitutional and political history. In other words, both followed the method of positivism that Leopold von Ranke established and highlighted with the famous sentence that the historian's task is to describe what eventually happened. The famous original sentence is, wie es eigentlich gewesen. After Ranke's, in the 19th century, during the formation of modern history as a professional science, history and legal history were joined together closely through the history of the state and political history. Moreover, in countries like England or Hungary, where there was a so-called ancient or historic constitution still in effect, the past built up an organic part of the present just because of the historic and legal customary character of the ancient constitution. Perhaps this inseparability of the past and the present was the cause of the unity of history and legal history, or a unity even with the whole jurisprudence in some aspect, when any legal problems became a problem of the past due to customary law. This unity of history and legal history can be defined even organic, while the connection of history and jurisprudence in broad sense is of course much less, but still not negligible. Recently, this organic unity has been dissolved in such an extent that even there is hardly any discourse between history and legal history. We can wonder why. What has happened in this 1.5 century? What happened? Occurred during that period, or was the difference an immanent part of the two disciplines? After Ranke's guidance, as the Annales or Annals school appeared in history, and in legal history, dogmatists, basically the Romanists, overruled the historic approach. In other words, the ideas of the Germanists and historicism or historicizing, both in Germany and Hungary, the two professions started their separation. In history, new trends, methods, and background philosophies appeared. For example, the structuralist historiography, the quantitative historiography, the historic anthropology, the microhistory, and after that, the crisis and the return to the biographies. While in jurisprudence, and especially in legal history, the concept of legal institution, Rechtsinstitut, of Max Weber, and his concept of the ideal type led to the approach that is far more dogmatic and institutional for a historian. And especially, this approach is out of context, anachronistic, and therefore historically misleading. While for a legal historian, time and events are not that important as for the former group, because when a judge applied the law in the past and the scholar reviews it later or even in the present, the judge must have examined the dogmatics, the meaning of the legal concept, and the text of the law, especially in a semi-precedent or formerly customary legal system as the Hungarian one. This is also true for the legal systems where the application of law is mainly or mostly exegetic, like in France. The difference between history and legal history can be detected by the fact that the historic interpretation of the legal norms in the practice becomes irrelevant or even inadequate in most cases. Consequently, the historic works become mostly irrelevant in legal history and in jurisprudence too. This is not surprising if we consider that the historic interpretation of law is outnumbered in the legal practice by the interpretation focusing to the very text of the law, that's the exegetic interpretation, and by the dogmatic conceptual interpretation when the core of the legal concept is examined in an abstract way. This is the reason why the judge will not dive into the core of the historic context of the case with the help of the historian's work. Furthermore, we must not forget the interpretation focusing to the aim of the law, the teleological interpretation, and the grammatical interpretation that examines the linguistic structures and again, both ignores the past as the context of the case. For example, the legal historian is interested at most in the content of a royal charter from the Middle Ages, while a historian in the field of humanities is keen to know whether it was an original manuscript or a copy, how the textual tradition developed through the ages, who the author was, where he studied, etc. In parallel, for the historians, the works of legal history are far more judicial, therefore very narrow-minded in a neutral professional sense. Thus, their methodology and approach is too strict, even anachronistic, or they are composed in a legal parlance that frightens the historians. Therefore, the previous organic unity or close relation between history and legal history has formed two different separate disciplines that are more and more beyond the mark and are working side by side. The aim of this lecture is a short attempt to provoke you to think on the exact time, place, and reason of the separation of history and legal history. Moreover, were they united at all, or they were just closely connected to each other by keeping their own character? In the followings, we examine the basic skills that are gained during the compulsory education before the legal or historic studies at the university. These skills mean the beginnings of the socialization of both the jurists and historians towards society, including the law and the past. After that, we shall focus on the approach towards institutions and time as these being the two marking elements of each discipline. I hope the short analysis will raise you further questions that I intend to discuss after the lecture. So let's see the training and basic skills. The official and professional education of the historians only started at the last 3 decades of the 19th century, while the legal training dates back to the Romans. In the first 2 years at the universities of the Middle Ages and of the early modern age, the human studies or humanities, studia humanitatis, served to lay the grounds for the following degrees of law, medicine, and theology by teaching the 7 liberal arts, the septem artes liberales, as the foundation of the 3 upper degrees over the bachelor studies. In Hungary, according to the Act Ratio Educationis of 1806, students had to take Hungarian in the first and universal history in the second year of the bachelor degree. The purpose of history as a subject in this aspect is the same as in the Middle Ages, namely to provide the basic and general knowledge for the following studies. Besides this general knowledge, the history of institutions like the parliament, the king, and the government, etc., as the backbone of both legal history and history as a subject, is still a component of the curriculum in both elementary and secondary grammar schools until nowadays. Considering the general and ground-laying character of both primary and secondary education, the framing of the legal character of the most important empires, monarchies of a certain time and place can be fulfilled only in its static form, usually focusing to the realm of a famous and important monarch. Summarizing this part, one difference between history and legal history lies in the education and professionalization of historians and lawyers. With the emergence of the modern universities, the Faculty of Humanities, and the education of the several disciplines at them started to develop. Thus, the modern science of history was born, and there came out new generations of historians who obtained their training as professional historians with their own code of discipline, paradigms, etc. So the historians were mainly no more autodidact lawyers, noblemen, and clerics. They were professional scholars having their own new, modern, and dynamic discipline. On the other hand, jurisprudence is a very ancient profession with separate faculties from the birth of the European University of the Middle Ages. Their method and the purpose of law is far much older than the European University itself, because it dates back to the Romans. After the short summary of trainings, we shall move to the fields of skills. Presumably, the belief, I did perform well in history, therefore I came to study law, originates from the 2 elements of history as a subject, namely, that it provides the general knowledge on society and that it deals with the structure of the states of certain epochs. It is not surprising if we consider that until the final exam of secondary grammar school, studying history means the formation and making of our picture on society. And for those who study further, but not in the field of social sciences in a broad sense, history means the last phase of their formal education and knowledge on society. The subject of literature that developed originally from the basic studies of grammar and rhetoric establishes the necessary legal skills with the method of grammatical, conceptual, and textual analysis for the lawyers during the class. Either we put the question what a poem, a novel say to us on that very day of the class, or what they say at the very moment of their composition as a reaction to the given circumstances of the past. Finally, the question pivots on how the reader interprets a text and its effect to the present or to the very reader, or on what the author could have thought during or as a result of the composition in the past. Since the subjects of history and literature are the same for future lawyers and historians, and they make up a mandatory part as well in the final exam as in the entrance procedure to a university, we can summarize the most important and common functions and skills that later determine both history and legal history characteristically. During the education of history, these are the expansion of the general knowledge, the presence of the approach towards the history of state institutions, the political history, or the history of events in the center, and finally the function of the acts and deeds of the monarch, especially in case of legislation as a reaction to certain circumstances. While we are learning grammar and literature on the one hand, we focus on the context of the past. That is, during the analysis, we regard the text as the author's answer to a phenomenon in the past, and we examine the relationship between the context and the author's reaction. This is called reactive contextual approach in this working terminology. On the other hand, the skills of conceptual, textual, and grammatical interpretation that focus just on the text at the time of the analysis, so on the very present, are the capabilities that students must acquire before they enter to university. This can be interpreted as the exegetic or textual conceptual approach. Again, I emphasize it just as a working term of arts in this lecture. From the two approaches, the latter interpretation is the one which appears during the examination of the text of the laws, while the reactive and contextual way of examination mainly belongs to the sphere of historical methods or legal history. Therefore, in a first level of examination, the person who wants to enroll for law school should take up literature subjects instead of history if we regard the skills that are needed for the analysis of the text of the law. Thus, seemingly and deliberately, in a first level, instead of the history as a subject that reveals the political issues and shows a closer connection to the law, literature that is usually the basic subject for human studies is the one that provides those skills that come from the demand of exegetic interpretation and are necessary for a law student. Because of the difference in the point of views and in the skills improved, schools should make the students aware of the importance of literature contrary to history. Certainly, the teleological and historical contextual interpretations are at least, if not in more extent, as important for legal history as the conceptual, dogmatic, and grammatical interpretation. We shall emphasize that it is true only if we remain at the first level of our examination that is close to the needs of jurisprudence. Let's see the approach towards institutions and concepts. A historian basically draws the context. He or she uncovers the background and unique events of the legal institution, of the legislation, and of the judgment. He or she reveals the social, economic, and political environment of the single case. He or she describes the personal interests, goals, and conditions of the case and the lawmaker. In this approach, the law itself is nothing more but the product or result that reflects the will of the lawmaker or of the person that applies the law, let them be a general assembly of the estates, a city council, or some patrician families. In other words, the answer to this background environment, collision of interests, etc., is a reaction that appears in legal texts, let them be either laws or judgments. Therefore, in the approach of a historian, institutions are determined by individual, separate events, conditions, or personal interests. Thus, for them, the judicial long-term examination of the institutions is just out of context. At most, the result of the legal examination can be nothing more but a construction of a legal concept, a phenomenon that never existed in reality. From the point of view of a historian, for example, the examination of the legal concept or institution of capital punishment from, let's say, Hammurabi to present-day US is methodologically unacceptable because in this way, there should be direct relation between the political settlement or the social economic establishment of the old Babylonian Empire and the US, but of course, there is no such. Besides this, proving the interactions between foreign legal systems, legal institutions, and legislations is a moorland, a controversial issue, because if the foreign impact on the will of the lawmaker and the legal reception is as output are not verifiable by textual tradition or by other direct ways like the description of the foreign trip of Peter the Great of Russia, then we cannot speak of legal reception, but only just of similarity. Thus, the phenomenon is not a reception, a takeover, but a parallelism, a mere coincidence. This methodological controversy of comparative law for historians comes from the reactive function of law to the social, economic, and political environment. These conditions are emerged and get their meaning within the borders of a specific country. Therefore, the foreign traits that are tempting to be compared belong to another foreign country and development. The king of medieval France and Poland cannot be compared in this point of view because the development of the concept of the king was step by step determined by different factors. So the reaction, the answer, and the whole development were different too. Remaining by domestic affairs, the king of an epoch may not be compared to the king of another age, even in the same country, because an age raises different questions and gives different answers that of the latter, so comparison becomes by time meaningless and shoreless. For example, the question regarding the concept of the king, what's the similarity between St. Stephen of the 11th century and Charles IV of the 20th century, the first and the last kings of Hungary, is relevant scholarly, yet there is not a historian that would undertake this examination in its form because of the long duration of time. The reason of this reluctance lies in the reactive approach that we discussed before. Thus, for historians, the history of institutions, concepts, and in this way, legal history too, is the history of the answer given to a certain and specific and contemporary political, social, economic questions and events. Therefore, there is no autonomous, organic development of institutions and concepts, because the change in the concept is provoked by a specific event or problem to be solved by legal means. The other reason lies in the different approach to time. For a historian, the question of time means historicizing, that is, the procedure how a present phenomenon becomes part of the past. For a lawyer, it means the time when a law is put into force or come into effect, so the moment from when it is applicable before the court. To be able to step further to the second level of our investigation, we shall look at the different attitudes towards time. Although a historian puts her questions in the present and looks at the problems of the past as the impact of his or her own present, the historian always intends to catch the past element. That is, the aim is historicizing. It is true even if this very question that was raised in the present is in fact the evidence that the historian wants to understand the present. Therefore, the problems of the past are actually the problems of the present. Therefore, the object of the examination of the historian is the present, while the means for that is the past. The evidence for this statement are for example, the topics and the title of the present day volumes, the history of information, the gender point of view, whatever history, the nature consciousness, the protection of the environment, the networks, the colonialization, etc. And these topics did not emerge a century ago, or if they did, the form and the content of them were different. For example, let's see the topics of spying, or later terminology, intelligence, or the Hungarian concept of great women, that is the great baronesses, countesses, etc., or even queens or princesses, and the role of kinship in nobility, etc. For nowadays, these are called information, networking, gender issues. For the historian, the examination of the past and the understanding of the present are in interaction. And regarding the differences of emphasis, there are two poles. One endpoint is the approach that ignores interpretation and moral judgments and concentrates purely on the description of dates, facts, and events. This is the positivist approach that Leopold von Ranke represented by declaring that a historian must collect and describe what eventually happened and nothing more. The other approach actualizes the problems and the phenomenon of the past. This way, historians adapt the past to the present or the other way around. Moreover, they may search for even a direct connection between the past and the present or even future. They are inclined to over-interpretation and thus establish timeless continuity. The previous approach wants to understand and study the past, while the latter one wants to study from the past by answering the question of what history means to us today, the famous Historia est magistra vitae concept. Thus, the historian puts the question in the present to ask the past. Therefore, the direction of this inquiry is backward, from present to the past. The historian intends to catch the origin, the starting point of a certain institution or concept, and then the functioning of the institution is examined at an exact time or during a specific monarch. Since the institutions in question are determined and influenced by the contemporary events, they are established and formed as the answer to a specific problem, so the events itself. Therefore, it is crucial for the historian to remain in the same historic epoch during the frame of inquiry. This is also the reason why the concept of the king cannot be examined relevantly during the age of Saint Stephen and Charles IV. Obviously, the challenges that the kings faced were different. Almost 9th century passed. The occurring similarities of the changes of the character of the kings were formal. In fact, they were plainly accidental. And now let's see some remarks to think on. History belongs to social sciences in broad sense, to humanities in strict sense. The question of social sciences and history is what happens now or what happened then. And they look at the past from the present. Jurisprudence belongs to the sciences of norms or behavior sciences in a way. And the question is what shall happen, how people behave now, how they should behave later. So jurists see the future from the present. The jurist thinks in an abstract way. Why the person who applies the law in practice make it concrete, exact. In the present, during the legal practice, the broad context is legally irrelevant. But in history, since everything is connected to everything, the context is relevant. In jurisprudence, the approach towards the institutions determines the approach to time, while in history, I think it is the opposite. For a historian, law is a reactive phenomenon, while for a jurist, the history of the institutions is autonomous. That is, the institutions have self-motion and their own separate development. The history of law or any other sciences belongs to history for the historian, while for the scholar of the specific science, it is part of that same science, while it belongs to the past. So, legal history is part of history for a historian, but it belongs to jurisprudence for a jurist. Is it true? Is legal history part of history or jurisprudence? Is there a third way? What makes legal history being a separate discipline? Or is it just a subdiscipline of either? Are there some additional characteristics that make legal history unique and different from history or from jurisprudence? Is legal history more than these two? Can legal history face towards future as law, and by doing this, be a part of jurisprudence? It is said that legal history provides data for the theory of law and for the positive law. Legal history joins the positive law with the legal past, that is, with itself. What makes legal history more than the examination of laws that are no more in effect? What is the use of legal history? On the one hand, legal history consists the reactive approach. However, both in education and regarding its long-term purpose, the task of legal history is to connect the actual positive law with the past, especially during legislation. Thus, legal history shall reflect to the point of view of the present that perhaps is far too exaggerating for a historian. The reason for this is that this view hints that there is a connection between, for example, Hammurabi and Stalin, and there is a universal truth or order that guides the world. And there is direct progress in history that can be recognized. And therefore, history is not just a sequence of events with more or less relevant connections and impacts, but a stairway to heaven, paradise, or utopia. The thought of the Pandectists, on the other hand, is totally in opposition with this approach, because in their approach, there are such abstract concepts that are independent of time and space. Although for a historian, there are no floating ideas in the sky, since they do not emerge from the imagination and creativity of the author. Yet, it is unnecessary to deny that there are institutions and ideas that start to live their own independent life after the original core event, or change the original intention of the author. Texts, events, or ideas objectify their original character, or in other words, they exteriorize their boundaries, or in a noun, it is called objectivation. If legal history is performed by historians, it belongs to history. Therefore, it focuses on society, economy, or on events. If it is practiced by jurists, it belongs to jurisprudence, and it puts institutions into the center, as we already discussed. At that point, the legal concept turns from its reactive function to social economic conditions and events into being an autonomous institution and concept, having its own self-motion and separates from the specific events. I guess this is the point when we forget the original background and we just interpret the text of the law. This may be the point when law becomes out of or without effect, or in a way, its effect becomes timeless. At this point, when historians examine the function of the law, it returns to its reactive function. When jurists, it remains in its autonomous status. So, law becomes a timeless concept with separate legal existence in the interpretation of the judges. Timelessness always refers to the present, we mustn't forget, because we cannot travel in time, but we are determined by our present world. The reason for this lies in the method of the judge or the other person who applies the law. During practice, this person does not, cannot, and shall not consider the social economic background, the cultural environment, the mentality, etc., because he or she is not a sociologist, an economist, but a judge. Legally, this may not even be done because these circumstances are legally irrelevant, cannot be proven, or just there is not a direct determination with the case. Unless the judge would exaggerate the conditions that are accompanying the case, but are eventually not decisive. This way, the conditio sine qua non principle were neglected. There are, of course, some exceptions when these side conditions are just the decisive facts of the case, but the judge may not usually apply these facts in a lawsuit during the practice. Summarizing this, the problem emerges when it comes to researching and teaching, especially legal history, because if your approach is that of a historian, you must consider the certain time, epoch, the context, the metajuristic elements of legal institutions, like background events, the person of the lawmakers, and or the various interests behind legislation, etc. Especially because in the present, historians are already aware of the background of the past and the determining factors of the certain period. While if you consider the dogmatic and legal approach, the positivist or exegetic interpretation or approach, then you should examine the legal concept in an institutional way and in a much broader term of time, the middle durée in terms of Fernand Braudel, a time frame that is sometimes far too long for a historian. Therefore, there comes a point when a scholar has to choose between the two approaches, and when a teacher must choose in reasoning the evolution, revolution, development, change of the legal concepts. More accurately, the question is whether events, persons, or institutions determine our society, history, and law. Does a judge act because of the surroundings, let them be society, public emotions, beliefs, politics, etc., or because of the binding legal dogmatics? Plainly, is the law the service made of politics? In other and more scientific words, does the law have an autonomous and inner motion, or is it depending, reactive, and therefore subordinate towards social demands and determination? Thus, the final and fundamental question leads us to the general principles of law, either in research or in teaching. The answer to this fundamental question is not obvious, and since one excludes the other, it is not the same which we teach at the Faculty of Law or Humanities. It is not obvious because if we exaggerate the binding effects of the background and society, then the judicial freedom will disappear. However, if we stick on dogmatics and the text of the law, then the law itself becomes too rigid for social problems, equity, etc. These two problems, thus our answer about the motion of law and at the same time, our approach to its history lead us finally to either the positivist or the meta-heuristic legal practice. At the same time, in the scholarly field, by the 21st century, legal historians and historians of the humanities cannot or hardly understand each other. The conversation of the two fields is not appropriate, and in the debates, the arguments usually fall to deaf ears. So far, this was the problem and the consequence of the difference of the two approaches, time and institutionalism. As a final conclusion, though I touched several aspects and the approach of both the research and the teaching of legal history from history, my intention is to work on step by step how legal history as a discipline separated from history. Thus, my object is to do further research on how the methods of a historian and the legal historian separated when they were writing about the same epoch, institution, or state in the same age, that is, when they were contemporaries of each other. This leads me to try whether the historian's methods or topics, for example, the quantitative historiography, the history of emotions, the history of borders, etc., are applicable to legal history or not. Furthermore, my aim is to examine the different purposes of history and law with the help of the two different approaches. That is, to consider the time and institutional way of examinations. Legal history lies in the permanent pressure of positive law. It is attached to it in formal education. The approach to the institutions, the classifications of the branches of law, may it be very anachronistic and unhistorical, the functional retrospection of present-day concepts, the abstract method of the conductists all determine the practice of jurisprudence and legal history. This is the reason why the hands of legal historians are bound by jurisprudence in opposition with the relevance of historic interpretations. Yet, a legal historian is aware of the fact that by passing time, the historicized character should be examined. That is, the specific problems of age, the reaction to these problems, to the context. Otherwise, the legal historian fall into the trap of anachronism. This consciousness, however, forces the legal historian to decide because the approaches exclude one and the other. Either the reactive function of law represented by the historians or the autonomous function of the jurist is accepted, but they cannot be performed at the same time. And still, the legal historian may never break from the institutions entirely because the law is just a kind, but a crucial kind of social construction, establishment, or product, whose changes in time is examined by the legal historian. Finally, legal history remains in the field of jurisprudence, even if the scholars of positive law ignores the historic and therefore more organic examination in their works, especially during legislation. By making the two characters of the approaches aware and the constant search for the differentia specifica of legal history, we can only reach from the historicizing of law to the right to historicize. The prospective outcome of this discourse is to be able to understand the reason and the progress of the separation of history from legal history, and as a consequence to initiate a new discussion between the two disciplines so that we could benefit from the results of the two. As a side effect, the whole research and the results function as self-reflection towards both disciplines. Therefore, both in teaching and research, the outcome can be fruitful and lead to further research. Burning bridges should remain the task of Clint Eastwood and Telly Savalas, but we shall always knock it off with those negative waves. Thank you. So
congratulations. It was really a wonderful lecture, and it may give us what to think about. And your approach that legal history is something different from history itself and law, it's really something that we should think about it, because indeed, as it keeps for integrating both things. There are cultural things also, according to Peter Heber. Law is a part of culture, history is also a part of culture, and it's important that we have having in our curricula in the law schools legal history. That's something that is really important. And for some time, as you know, in our history, that was a little bit forgotten. Let us say that was in the beginnings when law was founded, and then in the curricula, there was a little bit of absence of this kind of thoughts. And nowadays, they are more and more important. So thank you very much for your wonderful lecture. I don't know if there are any questions, comments.
Well, if I may.
Yes, Dimitris, you have the floor.
Thank you very much, dear Professor. Dear Balázs, you had won me already before you mentioned Telly Savalas, of course. I just wanted to take this, I guess, brilliant opportunity. You mentioned Charles IV, and I always wanted to know, he seeked to be reinstalled in 1921. He was the last Habsburg emperor, and he seeked to be reinstalled as your king, as the Hungarian king. Do you think, I think that tangents matters of legal history, of course. Do you think that it was only Horthy who avoided him back then?
Well, it's a heavy political question. I mean, heavy in the sense of its outcome, but of course we don't debate on the legal position of Charles IV. However, if you are a legitimist or a royalist, then you accept now George Habsburg as the true king of Hungary. But of course, the number of these people or persons are very marginal. Okay, of course, I know personally some of them, but you know that society is not just pure positive law, and there are the determining factors, and even the approach of society towards legitimism and towards the king has changed, and as methods and methodology, if we examine the concept of legitimism, is there right, is there lax for Charles IV to enter the throne or to occupy the throne again, is formally correct or content, or correct by content. And sometimes it's formally correct, but the content is different because there is some missing elements of the law. And in the other way, and the other time, formally is not so perfect, but as the intention of the law and the intention of the role of Charles IV, you can make it correct. So it's always the basic legal question that intention matters, form matters, or material or content matters, because sometimes, and especially in hard historic and turbulent times, you cannot have both. So that's the point. But if you don't have other questions, and I let the students, and just please ask me if you have any, but as I said, I have some pictures to share more, so that you think, and I promise you that sometimes you can make money from history as a lawyer. So this is, can you see this? Okay, so this is how the whole story started. Okay, and this is when you get to know more and more history, and you will be very sensitive to problems, especially in movie films, but it's not a problem. And this is, of course, when history cannot help you make money. However, there is one. This is a famous case when the body of Ramses II should have been transported. However, in France legal regime, you can transport a body even if it's a dead corpse, if it has papers. So you had to launch a paper for Ramses II himself. However, to fill in the dates, you have to be a historian because you cannot write any century, okay? And I asked you whether can we learn from history or not? Does history repeat himself? Because if we can learn from history and it repeats himself, then it means that we can read history just the same way as the dogmatists, that we have the text of the law and we can read it anytime, even 100 years later. So I brought you some pictures from the age of the Spanish flu, and I didn't bring you the text of the law and the regulation, but I participated in several conferences. So the text were basically copy-paste text. So this is the Spanish flu. This is wearing mask, and in an improper way, under the nose, here, above the nose. So we even have the clerks or the officers. We even have the message, stay at home. It has never been easier to save lives. As if I have seen these type of messages some years ago. We even have the commercial that in quarantine, you can use phone. Not cell phone, but phone, telephone. And this is not the rollers and some other equipments on the streets of yesterday. However, it's just at the turn of the 19th and the 20th century, before the First World War. Again, does history repeat himself or not? I don't know. We even have video calls with the bell phones. It's not happened reality, it's not invented, but it has the idea and the picture. And even at the backyard, we have some mobile airplane or cars. And history is said to be a constant development, especially if you regard the techniques and the technology. So, well, we have the phone, and yes, our ancestors had tails. And yes, the ancestors has buttons. And I am really curious of the equipment of the artificial intelligence that our ancestors had, for example, hardwares, because we will think and we will send message by interface in our brain as Elon Musk intended, or I don't know. And the other problem of the historic and the legal interpretation is that as a lawyer, as a jurist, we intend to step further and seek for the forerunners. However, in a structural way, or in a dogmatic way, or in an abstract way, as the Pandectists invented, we could basically describe any structure. England was leaving the union of the European countries. Okay, let's say it was a continent. However, Henry VIII has already done it. So nothing is new under the sun. Zoom. And I again thank for Andrea for the technological support. However, Zoom meetings are just modern science, not science, but sciences. Are you there? Can you hear me? Etc. This happened already in the first weeks of the pandemic. And my favorite, can history repeat himself? Well, the Vandals sack the capital. And we had the event at Washington, D.C. last year. Even the picture is the same, you know, just see the horns and see the column. And we have to be really aware of the forerunners because, you know, there is always a first one. And the past and the present, that was the other point of my lecture, how past and present misleads us, even if we use terminology. And for example, we say the state at the Middle Ages. Well, in the sense of Max Weber, there were no states at all. Can a man in the prehistoric age put something on his or her wall? Who knows? Or, it's a bit morbid one, but the soldier is just there at the right time and the right point in the view of William the Conqueror. Even we have the misleading language again, and the misleading texting and abbreviations that can a language of 100 years, 500 years, a millennium age texts be meaningful for us? Oh, if it's a tricky way to teach history. However, with the interpretation, of course, you can say that these are memes, these are mockings. Yes, these are very practical things to catch the interest for children towards history or legal history. However, I didn't want to quote any quotations from the books of authority behind me from English constitutional history or whatever book in this department, because it would be either boring or just a bit not so interesting. However, if we examine the text and we examine the approaches as how history is interpreted to our present day, then we can find exactly the same interpretations. And I don't think I have to mention that the gender studies and Henry VIII can be interpreted in an infinite way. However, we should progress with time. So then we could rearrange the things and reinterpret something in order to study from it. And again, the misleading terminology that we should be care of. And again, the interpretation of past, present, and what our aim and intention is with history or with law or legal history as a science. If we want to prove the LinkedIn element, we will see these pictures and we will recognize unintentionally because our eyes are just catching that we are interested in. So that's how we can have several interpretations by our own several intention and curiosity. On the picture, we can see Sissi or Elizabeth, the wife of Franz Joseph. And now we have the Franz Joseph with the same structure, how we can face and see history, and not just history, legal history and law as well. And this is another other proof that our point of view determines our result. What we think of Anne Boleyn. And this is the genre that every profession, occupation, film, hero, whatever, appeared some years ago on Facebook. This is again, at the upper part, you see the original way as buildings look like. However, of course, the paintings disappeared by the storms of history. And we could see it only with the methods and equipments of the 21st century, so with chemical analysis. However, in the Renaissance era, scholars thought that in the antiquity, everything was white. So after that, antiquity is white, even until nowadays, even if we know from archaeology that it was not white at all. And again, another sort of interpretation. And again, I emphasize that science works this way. The Vikings saved valuables from a burning house. No, of course not. It was a raid and it was a massacre, but you can interpret it in this way. And of course, it makes the whole science very subjective, but if we can talk about subjectivity if you like. And this is that it's a provocative question. However, we should really be careful of political interpretations. That what is the forerunner? What is ideologically the equivalent of this or that time? For example, François Furet said that only in the 21st century we can, and after the regime changes in 1990, can we discuss scholarly the French Revolution, because from now on until the end of the 20th century, all political ideologies started to originate themselves from Jean-Jacques Rousseau and from the French Revolution, which can be true and which may not be over. So maybe we will have some ideology after that that dates back to the French Revolution. And again, this epidemic or pandemic situation to help us understand to the methods and the importance, how we classify or how we do the grouping of data. We have globes, we have cover face, and we keep the distance. Well, one can think of the Middle Ages and one can think of the social distancing in the epidemic. And it's another way for the same phenomenon. This is how sometimes the present is just incorporated or infiltrated into the past, and even we don't recognize it. And again, why don't we interpret philosophy as we do, and in an actualized way? We even interpret Plato until nowadays. So cogito ergo sum, why not? Of course, the original was cogito ergo sum. I am being, therefore, I am thinking, therefore, I am. And again, the social distancing for the Victorian age. And this maybe should not be the last picture. However, it's a great picture to demonstrate the borders of comparison. Honor, love, freedom, or just the pure fact. And of course, we can compare these four elements, but we have totally different organic structures. Okay, and this was all the pictures. Thank you. Was it thought-provoking to ask you? Was it thought-provoking to give you some ideas, or it was just funny? And as a human resources manager said, that in a lecture, in every 15 minutes, there should be a break for fun. But I could not insert it into the PowerPoint, so that's why I did it after the lecture. So I see Dimitri. Okay, Professor.
Great. It was a wonderful way of finishing a wonderful lecture. Thank you very much. It couldn't be better. And by the way, I see there is a good tradition in your faculty in Hungary of teaching and studying war theory and war history, isn't it? I met some years ago in Portugal, and he keeps writing to me, Professor Gabor, Hamza Gabor, which is a colleague of yours, as far as I believe, already retired.
Yes.
And some others that I've met in some meetings, which is a great tradition that you are now one of the best representatives from your school of legal history. It's something great, and I'm glad that you keep on doing that. That is really important nowadays.
Yes, sure. There are some cooperation, and even my Dr. Vater was András Földi, another Roman lawyer. So that's how, and even we have the new source book, not source text, not just course book of comparative legal history that is really unique, because contrary to the original or traditional legal history course books that are very chronologic, historic, and focusing on the events and the political structures, with the touch of Roman lawyers, if I may say this, our comparative legal history course book have become as dogmatic as possible and did not harm the approach. So I guess we are somehow just in the balance and in the middle. And I don't see, well, that's why I tried to think in this lecture on the two sides, because I don't know how the further development will lead us, but we will have both the chronologic and both the dogmatic approach as the extent as a course book can allow it. So, of course, in research and in a paper, you can write more approaches, you can write and discuss more ways. The thing why I said they exclude one another, because even if you do the two approaches at the same time in the same paper, that will be like the two legs. But it's hard. It's really difficult to join the two together.
Yeah.
So yes, we have the cooperation with the Roman lawyers in comparative legal history and in the in the universal legal history, because in Hungarian legal history, it's the development is interesting, because in public law or in public legal development or in public legal history, we resemble with the ancient and historic constitution and with the customary law pretty much to the English legal settlement. However, in private law, even if we had customary law, in private law, we take up and we do the reception from German law and from German system. However, only in England and in the Hungarian kingdom, the Roman law are the one that was not in reception. So basically, we didn't have historically Roman legal impact because of our traditional customary legal system and because of the Ottoman Empire and the division of the country into three parts, etc. However, England and Hungary share some crucial points in their parallel legal development. Yet, in research now, especially with these joining of the two departments together and with the new course book, just 10 years. The course book is just celebrating its 10 years birthday. So that I think, and I do think it was fruitful to the legal history as a branch of jurisprudence.
Indeed, it was really important, and I'm glad you did it. We appreciate very much your contribution to the history of Europe, the history of institutions, with all the possible ways of looking at it. It's really great that you keep on doing, and I'll add from now on to my long list of specialists in legal history your name, because you deserve it. It was a wonderful lecture, and I hope I can read something more. And this is a way also of spreading what we are doing, and
yes.
I think it's a good opportunity. And the way you use English, it's always very good and helps a lot, because nowadays it's very difficult to communicate without using this tool, and it's an opportunity that we should use. So thank you very much. In Dimitri's name and in my name, we enjoy, and in Melanie's name, it was a great experience being here with you. We count on you for further initiatives of our Eötvös group, and
thank you.
Keep on doing the good work.
Thank you. Thank you. It was an honor
to
participate. Thank you. Thank you.
That was a great presentation. I appreciated that. And you made me think, in the future, what are the future legal scholars going to think of our legal history of today?
Yeah.
They're going to say, I don't really know what the truth is, the reality, but these people said this, and these people say this happened. So you've got a very important job, and I appreciated the perspective that you gave. So thank you very much.
Thank you. Thank you for the chance.
You're welcome. So see you next week, isn't it, Dimitris, at the same time?
Actually, it's on June 2nd.
Yeah, sorry, indeed.
Next week is a holiday in Germany.
Okay.
So we'll have our dear Professor Edelman on June 2nd.
Yeah, indeed. That's great. So we are looking forward to listening to her. So goodbye. See you.
Thank you. Bye, everyone.